Good morning. I'm Malcolm Neekirk. Today's topic is It's Not Fraud, which is going to give me an opportunity to talk to you about what that word really means and when it's safe to use it. Now, fraud is it's a word that gets bandied around an awful lot in insolvency. Um, people who don't work in insolvent often assume that if there's not enough money to pay everybody, then there must be fraud in there, which, as we know, is not true. And I have to say that my initial interest in insolvency arose from a case I was working very much on the periphery of, where there was a big Ponzi fraud going on. It's a case that hit the law reports at the time, called Berkeley Applegate, and I think I might even touch on it on a future coffee break briefing, as it's got some quite interesting principles in it. But there's a list here of things that people outside insolvency often think are fraud and are not. So it's not fraud if the business goes bust and is sold back to the same management as before as a phoenix. Always controversial, but almost always not a fraud. Similarly, wrongful trading, carrying on with the business when it's insolvent and actually having the creditors mounting up as a result. It's bad practice. There's potential civil liability for doing it. There's potential disqualification for doing it, but it's not fraud. Similarly, trading whilst insolvent, again, is not fraud. And I've sometimes heard people say it's illegal to trade whilst insolvent. And of course, we know it's not illegal to trade with insolvent. In fact, sometimes it's exactly the right thing to be doing, to be trading whilst insolvent, because it can be better to trade out of the insolvency than it would be to pull the plug and crystallize a loss. People who find themselves on the receiving end of a bad debt, they often feel that they've been defrauded, but it's not fraud. Not usually. It can be, but it usually isn't. Similarly, suppliers who see a failed retention of title claim, either because they haven't tried to retain title or because it's simply not possible in the circumstances to retain title, they feel defrauded, but it's not fraud. And as a general rule, insolvency, the inability of a business to pay its debts in full, inability of a business to pay its debts as they fall due, that's not fraud. Sometimes it can be, but as a general principle, it's not. So having talked about what is not fraud in insolvency, these are the 3 points that I would like to cover this morning. First of all, look at what fraud actually is. Secondly, to give you a list of reasons why you should be a bit reticent about accusing a director or the bankrupt of fraud, and perhaps a bit slow to do so. And then thirdly, I want to look at the circumstances when it actually might well be the right thing to do to run a fraud allegation. So the reason, I suppose, why I thought this might be a useful subject to cover one of these briefings, it arose from a small, fairly routine voluntary liquidation that I was involved in. Very familiar story. There was a £50,000 bounce back loan which bounced in and bounced out again without touching the sides. The money was in the company's bank account for, I think, less than 24 hours. There was no evidence that any of it had been used in any way to fund the company's business, and it seemed to have been used entirely to improve the standard of living of the directors. It was quite probably a misfeasance in terms of statutory duties to act in the best interest of the company and its creditors, and probably also on the basis of failure to comply with the terms on which the loan was granted in the first place. There may well have been an overdrawn director's loan account. The directors accounting for the payment out to them was certainly very sketchy, and at first blush it certainly looked like they had simply borrowed the money from the company and would therefore have to pay it back. And was it fraud? Perhaps it was. Perhaps if they had borrowed the money in the name of the company without the slightest intention of using it for the company's benefit, or indeed ever of paying it back, probably because they thought that it was an unsecured loan and the bank would just have to write it off, then that might have been fraud. In this case, the insolvency practitioner, they must have been quite hacked off with the directors, I suppose, because their letter demanding repayment accused the directors in fairly unambiguous terms of fraud. And as it turned out, that was actually not a terribly effective tactic, because the immediate response was from solicitors acting for the directors to demand evidence for the allegation and to insist that if an insolvency practitioner was going to allege fraud, they needed pretty good evidence to do so. And it actually got the whole thing off to rather a bad start from the insolvency practitioner's point of view. So let's look at what fraud is. There are many different definitions of fraud dealing with specific circumstances. There's a very general, generic definition of fraud in the criminal law, but if you boil it down to its essence, there are two components. There's an aspect of dishonesty, deceit, misinformation, and there's either financial gain to the fraudster or financial loss to their victims, and very often both. And the dishonest behavior, the deceit, that can either be lies about the intentions of the business, promises made about how the money will be dealt with, where the directors simply have got no real intention of carrying out those promises. Or they can be lies about facts. They can be misinformation that's given in the context with doing business with other people, where the truth is misstated either intentionally or because you're dealing with somebody who will simply say anything without bothering to check whether it's true or not. And fraud can sometimes be a deliberate plan. I'm sure we've all come across some fairly well organized people who are doing their absolute level best to make sure that financial payments through the banking system are misdirected and go to them rather than the correct recipient. Or it can be something which has just escalated over time, and I think that's often the case with many Ponzi schemes, where the management of the business are embarrassed about reporting a loss, so they decide to conceal it in the hope that the loss will be made good by a profit later on. And of course, having moved money from one client to another to cover the loss that the first client has suffered, they now need to make good two losses to put the money back to where it should be. And if they don't make good those two losses very quickly, they can end up moving more money about to hide the fact that they've moved money about to hide a loss. And over time, it just becomes the most complex web of deceit. I think that's often the case with Ponzi schemes. I think it's not that common that they are set up with the specific intention of defrauding people. The key thing really is there's a hierarchy, I suppose, here. That fraud is essentially, at its heart, it is a crime. It's criminal activity which involves dishonesty. And if you can prove fraud, then you can probably also prove misfeasance, which is not usually a crime, and usually involves a lack of care about what the person involved have been doing, rather than actual dishonesty. And moving down the hierarchy, an overdrawn director's loan account is simply a debt that has to be repaid. It doesn't even require a lack of care. And if it is a crime, it's what I might call a technical one, where because of the particular circumstances, there's an infringement of a piece of legislation. But simply borrowing money is of course not a crime. So that's a quick summary of what fraud is. I'm now going to move on to suggest some of the reasons why you should be a bit careful about accusing others of fraud. And here's a little list. At the top, I've got defamation, libel and slander. If you're accusing somebody of a crime, then that is inherently defamatory. I'll say a bit more, I'll say a word or two about each of these in a minute or so. The second one is GDPR, this statutory right to privacy that we all have, and information about allegations about crimes actually falls within the most sensitive category of information about people for the purposes of GDPR. So there's the highest degree of confidentiality required for you about those sorts of allegations. The third one is it can create antagonism, as in the example I gave you earlier, where the first reaction of the directors of being perhaps wrongfully or perhaps correctly accused of fraud was absolute fury. It wasn't really terribly helpful in that situation. The next one is that if you are accusing somebody of fraud, you're accusing them of dishonesty over and above everything else that you've got to prove, and you'll need evidence of dishonesty, and you'll need quite good evidence of that to be able to prove it. And the last one of the reasons I want to talk about is that there are professional conduct obligations on lawyers that may mean that they are reluctant to run an allegation of fraud. And as with the others, I'll say a bit more about that in a few minutes. So the first one of those, defamation, the laws of libel and slander. As you know, the difference between libel and slander is whether it's put in writing or not. If it's merely words spoken out loud, that's slander. If it's in writing or some other form of recording, then it's libel. And when it's libel, it's considered to be worse, and it's easier for the aggrieved person to bring a case. And the purpose of the law of libel is it's not about ensuring that the truth is told, it's actually about ensuring that people's reputation is protected. And it's a blunt instrument because it protects the reputation even of disreputable people. And the essence of a libel claim is that if you publish an allegation that's damaging about somebody, such as suggesting that they are dishonest, then that is damaging to their reputation. And that's all that they have to show, is that you have said something about them that is damaging to their reputation. And that means you then have to defend what you have said, and you have to prove that what you said is true, that they were actually dishonest. Otherwise, you have libeled them. And you can publish an allegation by some fairly informal means. It doesn't just mean headline of the newspapers. It can mean, for example, sending a report to the company's creditors in which you say that the director is being investigated for fraud, or it looks like the director has committed a fraud. And libel, my final point there is to say it's a useful legal tool for well-lawyered reprobates. And you find that some people do use the threat of libel as a way of preventing discussion of issues that they don't want to have discussed. And often it is the path of least resistance just to zip up your mouth and not make the allegation rather than get involved in a libel suit about it or not. The second one on my list was GDPR and the statutory right of privacy. As I said previously, allegations about suspected crimes are actually in the highest category of protection for personal data under GDPR. They are considered some of the most confidential information that you can hold about somebody, and you can share that, you can breach that obligation of confidence only if there is a legal right to do so, and if there is a legitimate reason for you to do so. And it would also have to be in accordance with your own privacy policy for you to do that. And you'd also have to make sure that the information that you are supplying to the other person has to be accurate. And an example of when this would be relevant, for example, is when you're making your D report, where GDPR would require you to make sure that you are giving accurate information in that D report. So it's probably better in terms of GDPR compliance for you to be making the report about the facts that you have discovered, not say anything about whether you think that that amounts to fraud or not, but just let the facts speak for themselves. The next on the list is yes, the emotional side to accusing somebody of fraud. They're going to see it as an attack on their reputation, on their morality, their personal ethics, and yes, they're quite likely to take it personally. They may well be angry about it. They may well want to put the record straight, even when you have actually put the record straight by telling them that they're a criminal. But it may well mean that the case is harder defended than it otherwise might be, and it might be a bit harder to settle. It might take a bit longer to come to a settlement than if you'd been perhaps a little more restrained in your initial allegations. Then there's the proof of the fraud, and in particular, over and above the facts of what happened, you're going to have to prove this additional element of dishonesty. Now, do you actually have the evidence of dishonesty? In this context, I'm not talking about you prosecuting the director for a crime. This is in terms of the information that you're giving in your D report, or perhaps you're building a case to recover money from the director. That's a civil matter. You don't have to prove your case beyond reasonable doubt, which you would be to bring a successful prosecution in a criminal trial. You only need to prove it on the civil balance of probabilities, which is that it's more likely than not that they were dishonest. But you do have to prove the dishonesty, and that means more than just the carelessness that you would have to show for misfeasance. And the court will actually want evidence, and credible evidence of that, because it is a serious thing for somebody to be found to be dishonest in court, and so the courts will only make that finding if there is sound evidence to support it. And then there's your lawyers, solicitors and barristers, and their professional code of ethics. We're not allowed to make a casual allegation of dishonesty. We can only allege dishonesty if there is a basic minimum amount of evidence that shows that, on the basis of what we know, it does look like they've been dishonest. And if there isn't that basic minimum level of evidence, then we may have to row back from the allegations. And if you've already put them in writing, that can be a little bit difficult, because we will not be able to carry on with the arguments that you might want us to run about fraud or dishonest behavior. And there's a flip side to that as well, which is that if you instruct a lawyer and you find that they are getting very enthusiastic about wanting to allege fraud or dishonesty, do think about these issues that I've mentioned just now, and do ask them to explain carefully exactly why they think it's necessary to bring a claim for fraud rather than a claim for, say, misfeasance. So, having told you lots of reasons why you should not accuse people of fraud, let's have a look at the circumstances when it might be right to allege it. And I've got 3 examples here. One is about statute of limitations and claims becoming time barred, the time limits for bringing claims. Second one is in the context of section 423, which is actually a type of fraud, which I'll explain in a minute or two. And the third thing I'm going to talk about here is the way that you can use an allegation of fraud, if it's well founded, to break open professional confidentiality rules and get you access to information that otherwise you might not see. So let's start looking at the statute of limitations, the 1980 Limitation Act, which is the main piece of legislation about when claims in court become time barred. And the general rule in the Limitation Act is that a claim will become time barred once it's more than 6 years old. But there are lots and lots of exceptions, and many cases when that normal rule does not apply, and there are some time limits that are shorter, sometimes quite a lot shorter than that, and there are some time limits that are longer than that. What's relevant here is that some claims for theft, and fraud is a type of theft, and some claims for fraud do not become time barred in accordance with the normal time limit. So an allegation of fraud, if it's one that you've got the evidence for, can sometimes get you past limitation problems. I'll talk a bit about section 423 as well, because I say that is a type of fraud. To bring a successful claim under section 423, firstly, you need to show that it's a transaction at an undervalue, which is where it sort of fits within the normal rules about transactions at an undervalue. But in addition to that, you have to prove that the transaction was intended to put assets beyond the reach of creditors, or it was intended to prejudice creditors in some other way. So that's the dishonesty part of it, the fact that there's a bad faith reason, bad faith intention for the transaction, which brings section 423 into the general category of fraud. And that means that unlike a transaction at an undervalue claim, you don't have the same issues about time limits for bringing a section 423 claim. For a transaction at an undervalue, the transaction must have happened at a relevant time, which normally means within the last 2 years before the company went into liquidation. But if you're able to show that it's a section 423 claim, you can go back further in time and you can start challenging transactions that happened more than 2 years before the liquidation started, sometimes quite a lot more than 2 years. For a transaction at an undervalue, you would have 6 years to bring the claim. Section 423 claim, you may have longer than that to bring it. It's not a good idea to wait a long time before bringing a claim, of course, but you may be able to extend the limitation period by claiming section 423 rather than a simple transaction at an undervalue. Third point I want to talk about is legal professional privilege. And normally, if the directors have been taking personal advice from a solicitor, or the bankrupt has been taking advice from a solicitor before the start of the insolvency, then that advice may well be privileged, may be confidential between them and their legal advisor, and something that you are not entitled to see. as an office holder, a liquidator, trustee and bankruptcy administrator and so on, you do have incredibly powerful rights to compel people to give you information about what happened before the insolvency happened. And when you enforce those rights, you can summon people to court, you can have them ordered to bring their records with them, and if they don't comply, they can even be arrested and locked up. So tremendously powerful, tremendously useful, but normally those powers will not open privileged files. However, they can if the issue is one of fraud. So if you need to see the solicitor's files to find out the reason why the family home was put on trust before the bankruptcy, you may, if you can allege Section 423, you may be able to get access to those files that would otherwise be privileged. So those are basically the 3 points that I wanted to cover this morning. Firstly, to talk about what fraud is. Secondly, a general warning about why you should be careful to throw accusations of fraud about. And thirdly, a quick look at some of the circumstances when it may be sensible to accuse somebody of fraud. So we're on to the summary slide now. And fraud is, it generally involves dishonesty, deceit, at least a reckless disregard for the truth and commitments that people have got. But if you can bring a claim for fraud, you can usually also bring another claim for something like misfeasance or debt or something like that, which is going to be easier to prove and is going to be a better line of attack probably. Then I spoke about why you should not casually accuse somebody of fraud, and there were these 5 subheadings. You could be sued for libel. You could find yourself having to deal with a complaint to the Information Commissioner's Office that you have broken the statutory duty of confidentiality. You could have to deal with emotions that are running high and which need to be calmed down before you can bring the matter to a successful conclusion. It may be that you find that you simply don't have the evidence to succeed in a claim that involves fraud, and you may find that you don't have the evidence to be able to persuade your lawyers that it's a case that should be run as a fraud claim. And then we looked at some of the reasons for alleging fraud, and they're essentially technical litigation reasons that might allow you to bring claims that would otherwise be time barred, or perhaps to get evidence from files that would otherwise be closed to you as privileged. And of course, sometimes there is no better way of fighting the case. Sometimes the other options you've got simply won't work and you have to allege fraud. So this is the point where if you've got any questions, I will be very happy to take them now. But as I said before, if you'd like to raise a question with me directly afterwards, I'll be very happy to deal with it that way. I don't see any questions at present, so I will just move on now to give you the key dates for your diary. Our next coffee break briefing on the 13th of March. And as I said, I'll be talking about GDPR there, but in some practical aspects in terms of how it may affect business sales and how to deal with subject access requests for information from your files. There's then a reminder that next month we've got the R3 Southern and Thames Valley Forum, which is in Reading, 23rd and 24th of March. You'll be glad to know I'm not going to be speaking at that, but I have been involved with the organising committee of it. I think it'll be a really good event. The bookings are now open for it, so it'd be great to see you there if you'd like to come along to it. And we've also got our 2nd annual insolvency conference, which is being scheduled for the 12th of May. We've got a lovely venue in Christchurch here on the south coast overlooking the river. I'm doing my level best to ensure it'll be a sunny day for it. It should be a lot of fun, good day out, and I hope to see you at that. But please stick the date in the diary for now, keep it free, and there'll be information about how to book yourself on it coming out shortly. And if you need to contact us, if you've got any questions you'd like to raise, there's my phone number, there's my email address, and please do get in touch if you'd like to. And with that, thank you all very much for your attention today. Hope to see you again next month. And thank you all very much, and goodbye.